responding. I don't like that. When I have standing, it's different. If I have standing, we're going full bore, full steam ahead. Damn the torpedoes. Why is nobody here? Maybe I've done a thing. Let's see here. Oh, good day, Valerian Gamer. Hello. How are you? Good morning, or afternoon, or evening, or night. We have Penny in the background here for your entertainment. Nobody. Thank you. I was not calling you nobody, I swear. We have Penny in the background for your entertainment. My wife is here, so there we go. That's awesome. This is great. No, I'm just complaining. Everybody hit the chat to reassure me that you're all here. No, Wall, hello, Leaky Glock, Katrina. No, I know you all will be here. I know it takes like 5 minutes for everyone to filter in, which is why I used to start early. And I'm sorry that I'm catching up. I will be okay. This was actually the week that I was supposed to get back to it, and then two things happened. One, I found out that my uncle died last year, and no one told me. So that's where things are at with my family. And I have, I'll leave the other bad news to the end. Oh, Lucy is also watching, my cat, my other cat. So this is Penny, and that's Lucy down with Kaylee. Hello, Doc Spire. Hello, Jer. Hello, Katrina. Welcome. Today we're going to be talking about the text that's not that, yeah, this text will be read about, but this is it. The United States Court of Appeals for the Fifth Circuit in the case of UMG Recordings et al. Versus the Internet Service Provider Grande Communications Networks LLC. This is another one of those ISP cases where music copyright holders managed to hold an ISP liable for the copyright infringement of their users. So this is not where the ISP is accused of stealing these songs themselves through infringement. The ISP did not go and get music illegally, as far as I know. It's the ISP's users. And I guess we should go over the law again. Let me go bring that up. I'll just shut up for a second. What was it? It's 512. It's like, thank you. I'll just accept the cookies in my cookieless browser. I appreciate that you keep trying. It's funny that they keep trying. Okay, so this is not correct. Why does this look so bad? There we go. So this is the DMCA, or just one section of it. It's the major section, 17 U.S.C. 512. The big one that we want to talk about is down here. I guess I've lost all of my highlights. Is it M? Where is it? Nope, it's not M. H, no. K, F. I'll find it. I used to know which one it was. Here we go. It's letter I. It's 512I, as in India. Conditions for eligibility. Remember, this is the section that gives internet service providers and other types of service providers immunity from copyright lawsuits. Now, there's always the question of if this is the only statute that gives them immunity, but this is one statute that gives them immunity. The 13 words, the other immunity doctrine, I forget what its name was, that one also still exists. There's still other principles of immunity doctrines, or not immunity doctrines, but parental. Geez, I'm a lawyer. I can't remember what the name for respondeat superior is. There we go. So the principle of respondeat superior, that you're responsible for what your employees do. Well, you can also be responsible for what your users do. So anyway, back to this. To have immunity, or rather, quote unquote, the limitations on liability established by this section, They apply only if the service provider has reasonably adopted and implemented a policy that provides for the termination in appropriate circumstances of subscribers and account holders who are repeat infringers, and does not interfere with other standard technical measures, and the subscriber has to be informed, etc. But the major point of this section is to disconnect subscribers who are accused of infringement, or, well, see, I just let the cat out of the bag. Are they accused, or is it proven? It just says, and this is the inexact language of laws, that we need our legislatures to be much more exact when they write these things. What do they mean? Who are repeat infringers. They exist as repeat infringers, great, but we don't know how they got there. Do they have to be proven? Do they just need to be accused? And then that's one of the big questions I want you to think of when we're doing this, is what is the standard for culpability in this case? Does a DMCA notice count as red flag knowledge of infringement, or is it just an accusation that's not been proven? I also have some questions for you to think about while we're reading this. Did the ISP present any evidence that the infringement was not willful? You'll see that willfulness comes into this in a big way. The award is much higher because the copyright infringement was considered willful. And this is willful on the part of the ISP. And then what should the law allow ISPs to do to accounts who are accused of copyright infringement? Since the law was written in this inexact way, and we're going to be disconnecting accounts that have multiple users who didn't infringe while one or more people did, but generally speaking, you don't have an entire account, in my experience, I've done this a lot, you don't have an entire account infringing. Sometimes, but that's been like only a couple cases out of a couple thousand that I've seen. So, without further ado, since this thing is rather long, let's take a look at what the Fifth Circuit wrote and try to figure out whether this is ripe for appeal to the Supreme Court or whether they've made some good law here. And they write, this appeal rises from the... we're off to a great start if I'm missing the first three words. This appeal arises from an action filed by plaintiffs, a group of major record labels, against Grande Communication Networks, a large internet service provider in Texas, for contributory copyright infringement. Judgment was entered below in plaintiff's favor, following a 3-week jury trial in which 10 jurors unanimously found Grande liable for willful contributory copyright infringement. The jury awarded plaintiffs $46+ million in statutory damages pursuant to the Copyright Act. During trial, Grande moved orally for judgment as a matter of law. So when you see JMOL, that's judgment as a matter of law, on the issue of liability, which the district court denied. Grande renewed its motion for judgment as a matter of law, and alternatively, a new trial on the issue of statutory damages, and the court again denied. Real quick, judgment as a matter of law is where you say, we don't need the jury. Even if the jury rules against me, the law still is in my favor, and you judge should override the jury or override some factual finding, because that factual finding really doesn't change anything. It's rare to use judgment as a matter of law and win, but it can happen. On appeal, Grande challenged the district court's rulings reflected in the order denying Grande renewed motion for JMOL or a new trial. They attacked the jury instructions and the final judgment. We hold, the Fifth Circuit here now, that the district court did not err in concluding the jury's verdict finding Grande liable for copyright infringement was supported both as a matter of law and by sufficient factual evidence. So we, the Fifth Circuit, do not reach plaintiff's conditional cross-appeal. However, the district court erred in granting JMOL that each of the songs, 1,403 songs, was eligible for a separate award of statutory damages. Accordingly, we affirm the jury's verdict, vacate the jury's damages award, and remand for a new trial on damages, and dismiss the cross-appeal. Let's take a look at why. This appeal follows a judgment entered in plaintiff's favor, 3-week jury trial, 10 jurors unanimously awarded $47 million. We got that. Peer-to-peer file sharing networks have existed for decades and enabled internet users to copy and distribute digital files directly to each other. Notable examples over the years include Napster, Grokster, Kazaa, and LimeWire. Peer-to-peer networks have been used to facilitate the unauthorized distribution of copies of copyrighted works. Each of the peer-to-peer networks mentioned above was sued by copyright owners for secondary copyright infringement. Each of the peer-to-peer networks mentioned above was sued by copyright owners for secondary copyright infringement, adjudicated to be liable, and shut down as a result. Let's try a new camera angle. Peer-to-peer networks have evolved over time, making them increasingly difficult for copyright owners to police. Plaintiffs argue at trial that peer-to-peer network BitTorrent substantially limits the ability of copyright owners to protect their rights in two important ways. First, BitTorrent is decentralized, meaning there is no single company or entity that manages the distribution of its software. Thus, there is no BitTorrent entity that can be sued like Napster or Grokster were. Well, there is the BitTorrent Foundation, but they're not doing anything illegal, so good luck. Second, BitTorrent is anonymous, meaning that its users cannot be identified by their names or physical addresses. Rather, they are identified by IP address, which are unique strings of characters identifying devices connected to networks. So these are Internet Protocol addresses. Only the ISPs operating these networks possess the records necessary to match IP addresses to specific Internet users. To crack down on copyright infringement, third-party companies have developed technologies to infiltrate BitTorrent and identify infringing users by their IP addresses. One such company, wait for it, is RightsCorp. RightsCorp is back. That's great. I'm so happy to hear that RightsCorp is back. Weren't they the ones a number of years ago that got a copyright ruling thrown out for... Wait, I'm looking at the wrong camera. So yeah, that's great that RightsCorp is back. I believe a long time ago we established some interesting new law thanks to RightsCorp. What was that? Man, am I getting old? I can't remember what RightsCorp did all those years ago. That was like a dozen years ago. RightsCorp. I might as well just bring it up in the browser. Why not? RightsCorp is a copyright enforcement company. Yeah, here we go. Morgan Peets of the Peets law firm filed a class action lawsuit against RightsCorp. A federal court ordered John Blaha. No, that's not. Okay, so apparently they did try to fight RightsCorp, but then the plaintiff backed out and got sanctioned for that, I think. Not sanctioned in that sense, but with attorney's fees. Okay. Yeah, I seem to remember that there was one, but maybe I forget what they did. The RightsCorp, as far as I remember, was the one that established the principle that you can't sell just the right to sue. I think it was RightsCorp. Oh, maybe it was RightsHaven. Oh my God, am I getting these two mixed up? RightsHaven. Let's try this. Yeah. Yes, RightsHaven was a copyright case. I swear I'm a copyright attorney. RightsHaven filed a lawsuit against Democratic Underground, filed a counterclaim. No, this is not it. Yes, here it is. RightsHaven had not transferred any copyrights, but merely the right to sue, which is not a transferable right under copyright law. That's who RightsHaven was, not RightsCorp. Okay, my bad. It's not the same entity. It's RightsHaven versus RightsCorp. Sorry. I'll go back in my PDF hole here and hide a little bit. Okay, so it's not RightsHaven. It's RightsCorp. So I'll just read it normally then. One such company is RightsCorp, not to be confused with Rights Haven. Their proprietary technology interacts with BitTorrent users and obtains their agreement to distribute unauthorized copies of copyrighted works. So they become one of the peers. Records the relevant available details of that agreement, such as the user's IP address, what the infringed content is, cross-references the IP address against publicly available databases to find out which ISP is affiliated with that address. Go back to this. Generate and send infringement notices to the ISPs, and then reconnects with the IP address to download copies of other works. So they collect evidence of infringement using the publicly available BitTorrent data. The efficacy of Rights Corp's technologies is dependent on the participation of the ISP. Only the ISP possesses the records necessary to match specific IP addresses. Thus, when Rights Corp sends its notices to ISP informing them of the IP addresses of their subscribers engaging in infringing conduct, the ISPs are the only parties capable of identifying the infringing subscribers and addressing their misconduct. Because ISP involvement is critical to stemming the tide of copyright infringement, copyright law incentivizes ISPs to participate in addressing the conduct of their infringing subscribers. Section 512, the Digital Millennium Copyright Act, gives ISPs a complete defense, a safe harbor, to claims seeking damages for copyright infringement based on the activities of their users. That safe harbor defense is available to ISPs only if they meet certain threshold requirements. They have to have adopted and reasonably implemented a policy that provides for the termination of subscribers who are repeat infringers. However, this section also provides that an ISP's failure to qualify for this safe harbor shall not bear adversely on the consideration of a defense by the ISP that its conduct is not infringing under this title or any other defense. Section 512 thus balances the interests of copyright owners and ISPs. In the early 2000s, Grande began addressing copyright infringement by its subscribers through an abuse process, which the company employed to address illicit activity conducted on its network. At that time, when Grande received an infringement notice about one of its subscribers, Grande disconnected that subscriber's service. Grande then informed the subscriber and applied punitive measures if the conduct continued. One of Grande's trial witnesses agreed that subsequent infringements by the same subscriber led to account termination. Great. However, in 2009, the private equity firm ABRY Partners purchased Grande and installed a different company to manage Grande's operations. How many times in one's life does the downfall of a company start with a private equity firm? I'm doing it again. How many times in one's life do you see a private equity firm buying something just before it tanks? I'm just saying there seems to be a thing about private equity firms or hedge funds or investors or whoever buying something, squeezing all the money out of it, and then, oh, look, it's bankrupt. We can't do anything anymore. Must sell it to somebody else. This corporate sort of plundering, it's kind of a piracy of its own. What was wrong with following the law and giving longer term value to your shareholders instead of plundering the company and, by squeezing out the people who are doing the enforcement of the copyright thing that's preventing you from losing $50 million? I've not noticed that private equity firms have a lot of forethought. It's just me. Maybe you see it too. In October 2010, that company changed Grande's disconnect policy, termination policy. Under the new policy, Grande no longer terminated subscribers for copyright infringement, no matter how many infringement notices Grande received. As Grande's corporate representative at trial admitted, Grande could have received 1,000 notices about a customer, and it would not have terminated that customer for copyright infringement. If you remember the Cox case, it wasn't that Cox didn't have a termination policy. It's more that they didn't apply it. They even had like a 13 strikes situation, and the judge said, I could probably agree to a 13 strikes situation, but you didn't actually apply the 13 strikes rule. You just didn't disconnect anybody, or you reconnected them right away. So this is similar. Let's try to remember to switch that. Further, under the new policy, Grande did not take any remedial action to address infringing subscribers, such as suspending their accounts or requiring them to contact Grande to maintain their services. Instead, they would notify subscribers of the infringement complaints through letters that described the nature of the complaint and possible causes, and advised that any infringing conduct is unlawful and should cease. They maintained this policy for 7 years, until May 2017. In 2011, Rights Corp began sending notices via email to Grande pursuant to an agreement with certain music publishing companies. So easier to send DMCA notices via email than mail. Mail costs the cost of a mailing. Like, that's a lot less to do it via email when you're sending thousands or millions of these things. Between 2011 and when plaintiffs filed this lawsuit, Rights Corp sent more than 1.3 million infringement notices to Grande. Approximately 317,000 of them concerned works in this lawsuit. Each notice documented a specific instance of a Grande subscriber agreeing to distribute a copy of a Each notice documented a specific instance of a Grande subscriber agreeing to distribute a copy of a copyrighted work without authorization. These emails asked the ISP to forward the notice to the relevant subscriber and included a link for the subscriber to contact Rights Corp and settle the claim for a small sum. Okay, you need to know more about this too. So, DMCA notices can't contain, well, I'll rephrase it. DMCA notices there's no requirement or allowance for them to contain a settlement of claim notice. So I've been dealing with companies that send these DMCA settlement letters for a very, very long time. And I can tell you I've never had one client who got sued after not paying a DMCA settlement letter. That's not a guarantee. That's not a promise. That's not legal advice. That is not any way. You can't use past statistics to promise or guarantee that a future thing isn't going to happen. You can only make an assessment. And my professional assessment is that these companies don't actually do anything to you if you don't pay the $30. However, they try. It's kind of like a used car salesman. You go on the lot of the used car dealership and they're like, this much money, and you have to know to talk them down. And if you don't talk them down, well, you've probably paid way too much. Rights Corp also sent periodic roll-up reports to Grande, each of which summarized the infringement notices that Rights Corp had previously sent. The jury learned that in 1 year alone, Grande had been advised that more than 40 of its subscribers had infringed over 1,000 times, and one subscriber had infringed nearly 14,000 times. During the period when Grande was receiving Rights Corp's notices, but had a policy not to terminate subscribers' accounts, one of Grande's employees wrote an email to his colleagues explaining that Grande's policy had no limits, and that some of Grande's subscribers were up to their 54th notice with no process or remedy in place. The employee testified at trial that in April 2013, he was concerned that Grande was not in compliance with the law, but Grande did not change its policy. Nor did Grande change its policy after learning in December 2015 that a different ISP, Cox Communications, had been found liable for secondary copyright infringement based on its continued provision of internet services, etc. Shortly thereafter, that was a $1 billion judgment. That was a $1 billion judgment, and they are still fighting that to this day. Shortly thereafter, Grande undertook an internal investigation to determine how many Rights Corp's notices it had received over the years, and had internal discussions about a letter Rights Corp sent to Grande a year earlier, seeking a meeting to discuss how they could work collaboratively and address infringements by Grande subscribers. Yet Grande chose not to change its policy or meet with Rights Corp. It was not until after plaintiffs initiated this lawsuit that Grande resumed terminating subscribers for copyright infringement. That's a big deal. That's a big deal. We get sued and then we remember that the law exists. So, Grande's policy during the nearly 7 years at issue in this case not to terminate subscribers for copyright infringement contrasted with its policy during the same time period regarding subscribers who did not pay Grande's monthly fees. A trial record established that Grande consistently terminated the accounts of subscribers who stopped paying Grande's fees. One of Grande's witnesses admitted that Grande terminated non-paying subscribers 100% of the time during the time period relevant to this case, and Grande terminated thousands of subscribers for non-payment. So I came into this against the Fifth Circuit's ruling. Um, I have to admit that's pretty damning evidence. Um, Thousands of notices. Okay, at some point, I'm doing it again. Okay, at some point, thousands of notices should maybe cross into red flag knowledges. Ow, I can't speak today. So yeah, at some point, maybe thousands of notices should translate into some kind of red flag knowledge. I don't know. Where's your line? How many hundreds of notices do you think you need to get before a court can say, okay, well, you should have been contacting the subscriber and being like, hey, you're getting hundreds of notices, right? Maybe it's a dozen notices, maybe it's six notices. Maybe you should get like a notice of each one, and then like there should be a policy of like 5 times, 10 times or something. But geez, thousands of notices and still not terminated. I have to admit, there's something there, definitely. But I also don't agree that each of those DMCA notices is an adjudicated copyright infringement. In other words, the music copyright holders did not go and get a judgment against that subscriber and then come back and say, look, we've got 14,000 judgments or 1,403 judgments or whatever. You have to, terminate these 1,403 people. We got a judgment against this one guy. You got to terminate this one account. They didn't do that. They sent takedown notices, and I think it's still an open question in my mind whether a takedown notice is enough evidence of infringement to disconnect an account, or if it should be proven, adjudicated in a court of law or before the Copyright Claims Board, or at least let the customer respond and say, no, that wasn't me, if that wasn't them. The customer doesn't. I would say there's a due process violation here. If the ISP is to terminate under penalty of this lawsuit, if the ISP is to terminate the subscribers and the subscribers don't get any due process notice and meaningful opportunity to respond, maybe that's the next defense thing that I'm going to be doing for individuals who get terminated. We'll have to see how that plays out. Back to this. So plaintiffs filed suit against Grande, and a bunch of stuff happened. We're going to skip through some of it. The jury awarded $33,333 per song for each of 1,403 sound recordings. The jury found that Grande's infringement was willful, and Grande did not appeal that issue by accident. So they don't get to challenge the willfulness, because willfulness allows you to go above $30,000 per work up to $150,000, which is how you get above $30,000 to $33,333. Anyway, that's what's going on there. They didn't appeal the willfulness issue. It was a mistake. Grande's appeal challenges the district court's rulings, denying its judgment as a matter of law, challenging the jury instructions, and challenging the final judgment. We're going to skip jurisdiction because it's not a big deal. Pursuant to longstanding principles of secondary copyright liability, plaintiffs' claim against Grande for contributory copyright infringement had 4 elements. The plaintiffs own or have exclusive control over valid copyrights. Those copyrights were directly infringed by Grande's subscribers. Grande had knowledge of this infringing activity, and Grande somehow induced, caused, or materially contributed to that activity. The district court did not err in upholding the jury's unanimous liability verdict because plaintiffs satisfied each element legally and factually, according to the Fifth Circuit here. The court correctly interpreted the law and instructed the jury on the relevant legal standards in light of the factual issues disputed by the parties. Okay. We discuss each of the 4 elements in turn. So, to establish ownership, a plaintiff must prove the material is original. Okay, let's see if there's anything interesting in here, but I don't think we really need to read the court's analysis on did the music industry own copyrights. Grande did not challenge the rulings. Okay, so we're not going to skip much. We skip a page. To prove the second element, that the defendant copied constituent elements of plaintiff's work, a plaintiff must establish factual copying and substantial similarity. There's other ways, but that's the main one. Factual copying can be proved by direct or circumstantial evidence. The district court instructed the jury that to prove direct infringement, plaintiffs needed to establish that each work in the suit was infringed by distributing any part of the work without plaintiff's authorization. So that's the standard for direct copyright infringement. To find an unauthorized distribution, the jury could consider direct or circumstantial evidence, including evidence that copyrighted conduct was offered or distributed to a third party who is investigating or monitoring infringing activity. So this is the investigator. Was the investigation good? Plaintiff introduced testimony that Rights Corp reached an agreement with a Grande subscriber to distribute the work, as in negotiated a BitTorrent connection. Rights Corp sent Grande a notice of infringement. Rights Corp reapproached Grande users who had previously agreed to distribute the work, which is just a phrase saying they used BitTorrent, and they did it again. So they got another complete copy of the work. So this is like 2. Now they've done this twice. Plaintiffs' Trade Association, the RIAA, used an industry standard program called Audible Magic, which analyzes the contents of digital audio files. Okay, so whereas in my Strike 3 Holdings cases, they actually look at each file with their physical eyes, here I think they use Audible Magic. And each plaintiff had an employee personally familiar with plaintiff sound recordings listen to make sure that it's the same file. Okay, so we've established that the file is sound and that the IP address shared it twice, at least. Does that prove a particular person did anything? Cobbler, Nevada versus Gonzalez? That's the Ninth Circuit, so who knows if that applies here. Grande's key defense at trial was that plaintiff's evidence of direct infringement was unreliable. I agree. Grande does not challenge any of the evidence of direct infringement that plaintiffs offered. Gosh darn it. Grande instead asserts that because plaintiffs did not introduce the copyrighted songs at issue into evidence, the jury could not conduct a side-by-side comparison of the works. Disappointment. This is the look of disappointment. Your copyright attorney, your favorite copyright attorney, is disappointed that Grande did not challenge whether a DMCA notice is sufficient evidence of copyright infringement for 512I, for disconnection, for termination. We're getting these terrible rulings that make little sense until you find out these key details. They lost on something challengeable and they didn't challenge it. I am disappointed. Maybe there's a reason. I'm not sending anyone to the gallows, just disappointed. To support its argument that the jury did not get to make a side-by-side comparison of the works, they cite a couple cases. King, the plaintiff failed to produce the copies, and Bridgman, I don't know where Bridgman is cited here. The plaintiff brought a copyright infringement claim against a corporation. Oh, this is Bridgman. For its use and sale of a computer program known as ICUS, which he alleged infringed his copyright in another program. However, the plaintiff was unable to produce a copy of the ADS software. The court rejected plaintiff's contention that he need not produce evidence of the software. Okay. It's true that King and Bridgman contemplate side-by-side comparison of the works, but in those cases, the parties meaningfully disputed whether the defendant's alleged copies were substantially similar, and the only evidence about the contents of the works was oral testimony. As a result, the plaintiffs could not satisfy their burdens to prove that the defendant's alleged copies were substantially similar. Okay. Those circumstances differ from here, where Rights Corp or plaintiffs introduced extensive, forensically reliable evidence proving the files Rights Corp downloaded were exact copies of plaintiff's sound recordings. So the judge and the jury were both entitled to rely on the records generated by Audible Magic. Okay. I'm not super upset that the judge allowed this to happen, this not you don't have to have the jury actually hear the songs and then hear the infringing song when someone has testified that we did check. I guess, I guess certainly it would be part of discovery, wouldn't it? Like Grande would have requested this evidence in discovery and then at least analyzed it for themselves. So okay, I think I'm okay with that. I'm not okay with them not challenging that a DMCA notice is sufficient evidence of copyright infringement. I'm not saying that the DMCA notice couldn't be sufficient evidence. I'm just saying nobody's challenged it yet. So, the third element then. The district court applied the correct standards about willfulness. Plaintiffs were required to demonstrate that Grande knew of specific instances of infringement or was willfully blind of such instances of infringement, where willful blindness meant that Grande believed there was a high probability of a fact, but deliberately took steps to avoid learning it. Okay, so this might actually convince me on willful blindness. So red flag knowledge is known, should have known, or willful blindness. And willful blindness is a high probability of fact, but deliberately taking steps to avoid learning it. I'm hearing a weird noise from my front left tire in my car, but never mind, I'll worry about that some other day. That's willful blindness. You've had a high probability something is going on, you need to check it out, you don't. So 1,000 copyright notices, infringement notices, DMCA notices, unproven, but still 1,000 accusations, the ISP should check it out. Oh, okay, I kind of get that. At least under this law, we can dispute all day whether this law should exist, whether you should have a law connecting termination to copyright infringement for an internet connection when everybody needs an internet connection. But we have rules for driving in the U.S. and everybody needs a car. We have rules for lots of things that people need. So on some level, it's okay to have rules about ISPs and stuff. I just think this is a little harsh, especially for the people who are innocent. I'm always worried about the people who are innocent. The people who are guilty, I can defend them and get them the best outcome possible, but they're guilty. If you can get them off on a technicality or something, that's great, but usually on a civil case, it's difficult to do that. It's the innocent people that I'm super concerned about. They shouldn't have to suffer from someone else's crime or someone else's infringement or someone else's behavior. That's where I fall on these things. The district court correctly concluded that a jury had legally sufficient basis to find knowledge or willful blindness. So the jury is the fact finder. That means that they can find facts. Grande does not challenge the sufficiency of evidence supporting the jury's finding that it had knowledge or was willfully blind to. So therefore, it has abandoned any argument concerning willfulness. Finally, the fourth element is the crux of the appellate challenge. Grande makes several strong arguments. They are ultimately unavailing for the following reasons. First, we conclude the district court applied the correct legal standard by determining that Grande could be held secondarily liable if it induced or contributed or caused its subscribers' infringing activity. The district court explained at summary judgment and again after judgment that the purveyor of a technology capable of both infringing and non-infringing uses cannot hide behind the technology's non-infringing uses to shield itself from liability when the purveyor has induced, caused, or materially contributed to the infringer's activity. I always tell my clients this: as long as you don't contribute to the infringing activity, you cannot be held liable for someone else's. But if you help them in any way, go get that movie for me, then you've materially contributed and you can be held liable under this law. Grande contends the district court erred. The Supreme Court has recognized two and only two types of contributory copyright infringement, where the defendant distributes a product or service and where there is a clear or other affirmative step taken to foster infringement. Plaintiffs respond that this court has embraced the material contribution theory of liability, and the three Supreme Court opinions cited by Grande did not write material contribution out of the law. So we're creating new law here, and the Fifth Circuit is basically sending this up to the Supreme Court for this material contribution law. So we should get a ruling from the Supreme Court in a few years on whether or not the Fifth Circuit, and I guess the Cox decision did a good job. The Cox one is already up to the Supreme Court, I think, so one of these days. In 1999, our court recognized the validity of material contribution claims for contributory copyright infringement in Alcatel. In doing so, we adopted the elements of the contributory copyright infringement claim from the Second Circuit's Gershwin publishing decision. Gershwin recognized that contributory infringement claims stem from the common law doctrine that one who knowingly participates in or furthers a tortious act is jointly and severally liable with the prime tortfeasor. The court in Gershwin synthesized that common law principle into a rule that one who, with knowledge of infringing activity, induces, causes, or materially contributes to the infringing conduct of another may be held liable as a contributory infringer. Grande contends that material contribution is not a valid basis for contributory copyright infringement. Okay. As an initial matter, in both the Sony and Grokster cases, the court expressly embraced the common law standard for contributory infringement. Okay, so here's where we're going to get into the weeds of contributory infringement. I'm going to read a little bit of this, and then we'll start skimming, because really the court's going to do an analysis, and then we're going to have an answer. We don't really need to know how they got there so much. It's not that super interesting sometimes, but let's find out if it's interesting. In Sony, the court addressed the issue. So this is Sony Betamax versus I guess the movie industry that didn't want them to be able to make the Betamax tape recorder. Sony could be held secondarily liable for the infringements of their users. The question was whether selling a product that facilitated infringement standing alone was sufficient to impose contributory copyright liability. The court held it was not, which means you can still use Betamax or VHS tapes or other time-shifting technologies, and it's not copyright infringement without more. This mirrors the standard for contributory liability under patent law, which is confined to the knowing sale of a component especially made for use in connection with a particular patent. The court's analysis in Sony focused on the fact that the case involved the sale of a product because in such a case the defendant's contact with its customers ended at the moment of sale, and the defendant did not know what its customers did with the product thereafter. Like Sony, Grokster dealt with a defendant that distributed a product which facilitated infringement, specifically software that enabled users to share digital files through a peer-to-peer network. The Ninth Circuit had held that the defendant, was entitled to summary judgment because the software was capable of non-infringing uses. But the Supreme Court reversed, holding that while Sony prohibited imputing culpable intent from the distribution of the product alone, it did not displace other theories of secondary liability or require courts to ignore other evidence of the defendant's intent. Because the record in Grokster contained evidence that the defendant distributed the software with the object of promoting copyright infringement, summary judgment was not warranted. By holding that the distributor of a product that facilitates infringement can be liable, Grokster expanded the doctrine of contributory infringement. Before Grokster, the distributor of a product could not be held liable so long as the product was capable of substantial non-infringing uses. But after Grokster, an inducement claim could succeed against a distributor of a product if the distributor affirmatively induced future infringement, even if the product was capable of non-infringing uses. Here, Grande provides its subscribers with internet services on a continuous basis in exchange for subscription fees. Those actions create an ongoing relationship. Plaintiff's theory of liability in this case is not based on Grande's knowledge about its subscribers' likely future activities after the moment of sale, but rather on Grande's knowledge of its subscribers' actual infringements based on its ongoing relationship of those subscribers. Again, it says actual infringement. Did anybody ever prove infringement? I don't like that phrase, actual infringement. It says actual infringement. Based on subscribers' actual infringements. No one has proven these infringements. They have just shown evidence that an IP address associated with an account which this might be enough for you. I'm not saying it's not, but an IP address associated with an account was seen infringing at least twice, according to the court and testimony and the jury's findings and all that. So far, I have not heard any due process rights for those subscribers who got an opportunity to respond to those DMCA notices and say, "Hey, I didn't do this." Now, maybe the not responding. Maybe the court would say the not responding is the important part, that you didn't respond to a DMCA notice by calling the Grande and saying, "I didn't do it." Maybe you accepted it, but that's not what it says here. Because Sony and Grokster expressly addressed records where such continuing relationship did not exist, their holdings do not foreclose liability here. Let's continue. On the Twitter case, we note at the outset that it was litigated pursuant to the Justice Against Sponsors of Terrorism Act and did not mention copyright law. Because material contribution remained a viable theory, Twitter cannot furnish clear, contrary Supreme Court authority displacing Alcatel and Gershwin. Twitter underscores the general importance in all cases of secondary liability of demonstrating a direct nexus between the defendant's conduct and the underlying tort at issue. So a direct nexus between the defendant, in this case Grande's, conduct and the underlying tort, which is the subscribers or users or IP addresses infringement. I'm not saying that an IP address infringes automatically, but I'm saying we don't know who it is. Guys, you have to understand. I've seen everything. I've seen cases where someone gets sued for copyright infringement by a Strike 3 Holdings type entity, and we find out that the infringement may have occurred, but the infringement seems to have occurred on some secondary SSID, some secondary Wi-Fi name, because Comcast, for example, was providing customer premises equipment in the form of a modem and Wi-Fi router with an extra Wi-Fi SSID, giving the public access to the connection as well. You still got your connection, but the same IP address, as far as I'm aware, the same IP address on Information and Belief was also sharing a public SSID for Comcast to sell to other customers. Use our Comcast public Wi-Fi network or whatever. So everybody's modem router had a secondary Wi-Fi on it, at least for some period of time. And there were a number of people who had to declare their innocence. There were a number of people who paid settlements, probably didn't do anything wrong because the infringement was committed by somebody on the public Wi-Fi side. This doesn't go on everywhere, but there was definitely a period of time where that was prevalent. In Twitter, family members of a victim of an ISIS terrorist attack in Turkey sued 3 U.S. social media companies, alleging that the companies aided and abetted ISIS by permitting its members. Yeah, I remember this one. The court held that the aiding and abetting liability, which also derives from common law principles of secondary liability, requires courts to focus on the defendant's assistance to the tort for which plaintiffs seek to impose liability. Because defendants did not knowingly provide ISIS any assistance, they could not be liable for aiding and abetting. The court concluded that aiding and abetting streams are strongest where there is a direct nexus. When such a direct nexus exists, juries are more easily likely to infer that a defendant's conduct was culpable. In contrast to Twitter, the direct nexus between Grande's conduct and the tort for which plaintiffs seek redress is direct. The underlying tort at issue here is copyright infringement, specifically the unauthorized distribution of plaintiffs. Yeah, we got that. Grande provided those subscribers with the tools necessary to conduct those infringements, high-speed internet access, and continued doing so after learning those subscribers were repeatedly using those tools to infringe, in furtherance of a policy never to terminate subscribers for copyright infringement. I again renew my objection that this is a terrible reason or way to measure when you should terminate an internet user's account. But I can't deny this is the law, and I can't deny that the Fifth Circuit is applying the law here. Thus, the liability verdict here in Grande is consistent with Twitter. The direct nexus between Grande's conduct and the tort at issue permits an inference that Grande's knowing provision of internet services to infringing subscribers was actionable. The jury instructions. Did Grande induce, cause, or materially contribute to the infringing activity? I think we've gone over this enough. Grande takes issues with the simple measures standard. In several cases, online infringements with new technologies, the Ninth Circuit has imposed an additional step. In these cases, even when the defendant provides the tools necessary for infringement, the court requires inquiries into the defendant's simple measures taken to prevent further damage to copyrighted works. Grande contends that the line of simple measures cases is inopposite because it applies only to defendants who directly control content. However, the Ninth Circuit in Amazon clarified that it designed this test broadly for the context of cyberspace and for any defendants that provide internet access or services. That breadth was reflected in the test itself, which does not ask narrowly whether the defendant can remove access to the infringing content online, but more generally whether the defendant possesses reasonable and feasible means to prevent further damage to copyrighted works. Okay. Not really sure how that applied anyway. I guess because the district court gave basic measures instructions that did Grande have the ability to take basic measures to mitigate the copyright infringement by disconnecting the account. And yes, of course, the jury said yes. Another instruction that intentionally continuing to provide access constitutes a material contribution. And was that correct? The closest on-point authorities are BMG and Cox. The Fourth Circuit held that subscription services like those provided by an ISP, liability could be imposed if the service provider learns that its customers are using its services to infringe and nonetheless renews the lease to those infringing customers. Again, did they learn through DMCA takedown notices, or did they learn through copyright adjudications? They didn't learn through copyright adjudications. They learned through DMCA takedown notices, and they didn't challenge that. I think they should have challenged that. In Cox, the Fourth Circuit affirmed a jury's finding that Cox was willfully liable for copyright infringement because it intentionally continued providing internet service to infringing subscribers. We don't currently have a Supreme Court ruling on that, and I think we're looking forward to getting one sometime soon. The the panel says, these are not weak arguments, but the Fourth Circuit heard these same arguments about Grokster and BMG and Twitter and Sony. Applying the rules of fault-based liability derived from common law explicitly endorsed by Grokster, the court in BMG found the requisite intent in the ISP's continued provision of services that were substantially certain to result in infringement. We get it. The judges here think that there's enough evidence that Grande knew what was going on. I forgot to do this again. That Grande knew what was going on and didn't do anything about it. And therefore, that's a material contribution. So did they provide the tools necessary to infringe? Yeah, we can argue about that all day, but the court said that providing internet access where the internet access is used to infringe is enough. That's what the court said. I don't agree. I kind of feel like this is like, how about this? The city connects me up to water, sewer, and electric. Let's say that I use the electricity and the water to make crystal meth in the style of Breaking Bad. Is the city guilty if they find out that I'm using the water illegally and they don't turn off my water supply and they don't turn off my electricity? Okay, but we don't do this elsewhere. We don't turn off someone's water and electricity and all that. But I guess the internet is not necessary for life functions or necessary for heating your house or running your appliances or running your heat, running your water. Some places you have to pump water. So yeah, I guess that's why we don't do that. But it does seem like internet is up there with one of the more important things in life. You don't get disconnected for improperly using your water or sewer or electric. You do get disconnected for improperly using your gas. I'm pretty sure they do that one, but that's really dangerous. I wouldn't say that copyright infringement is the same level of danger as a gas explosion, but I digress. Maybe that's a little bit too far off the track here. Next, we consider Grande's damages argument, a question of first impression. Each of plaintiff's 1,403 sound recordings that was infringed is entitled to an individual statutory damages award. But Grande contends the text of the Copyright Act requires a different result. Whenever more than one of those recordings appeared on the same album, plaintiffs are entitled to one statutory damage award per album, not per song, regardless of how many individual recordings were on the album, regardless of how many were infringed. Grande has the better reading of that statute, says the Fifth Circuit. So a copyright owner may elect to collect an award of statutory damages for all infringements involved in the action with respect to any one work in a sum of not less than $750 or more than $30,000. It can go higher with willfulness. The Copyright Act defines a compilation as a work formed by the Copyright Act defines a compilation as a work formed by the collection and assembling of pre-existing materials, etc. The collective works, which are a number of contributions constituting separate independent works assembled into a collective whole, that's an album. The Supreme Court has made clear that the starting point for our analysis is the statute. The plain language of the Copyright Act mandates the conclusion that each registered compilation is eligible for only one award of damages, statutory damages. In concluding otherwise, the district court found that the majority of case law holds that when individual sound recordings are available as individual works, a plaintiff can recover one statutory damage award per recording, not per album. Plaintiffs contend the majority of the 7 circuits have considered the question and apply a functional test to look to where the market assigns value, deciding whether the parts of the compilation are individually eligible for statutory damages or together as a whole. In addition to the 7th Circuit, the D.C. Circuit, 1st, 9th, 11th Circuits also take this approach. Contrary to plaintiffs' assertion, the 2nd Circuit has not adopted this test. In EMI Christian Music Group versus MP3 Tunes, the 2nd Circuit acknowledged that materials that are sold as part of a compilation, such as songs on an album, ordinarily are not deemed separate works for statutory damages. The 2nd Circuit held another case, Bryant, an album falls within the Copyright Act's expansive definition of a compilation. When a copyright holder or publisher issues material on an independent basis, the law permits a statutory damage award for each individual work. The fact that each song may have received a separate copyright and that the infringer sold the songs individually is irrelevant to this analysis. The 4th Circuit's approach also has uncertainty. In Zoom versus Image Line, XOOM, Zoom, not ZOOM, the 2nd Circuit, it followed the 2nd Circuit's approach in Bryant. The court determined that 2 collections of several thousand digital images protected under only 2 copyright registrations were compilations and thus only eligible for 2 statutory damage awards instead of 1. Or, excuse me, instead of 1 for each infringement. Instead of 1 for each infringement. As the 7th Circuit in Sullivan recognized, this qualification is substantial and seems to suggest that the 4th Circuit may chart a different course, perhaps one followed by most other circuits on different facts. Plaintiffs urge this court to adopt the majority approach and affirm the ruling that each song is its own independent copyright, gets its own statutory damage award. But nothing in the statute permits plaintiff to recover damages for each individual song just because the song was exploited individually or began to live its own copyright life. As plaintiffs concede, each album constitutes a compilation, and the statutory text constrains plaintiffs' eligible award to statutory damages for each album. Record evidence supports this conclusion. These are registered as a compilation of sound recordings in a collective work. They are not sold individually primarily. Although I'm surprised because I think you can buy the songs off of the album like on iTunes or whatever individually, but it's still sold and registered as an album. So we can skip a little bit. All that remains is the appropriate remedy. For the first time on appeal, Grande asked this court to reverse the district court's denial of judgment as a matter of law and modify the statutory damages award to $22 million based on 662 works. In its renewed judgment as a matter of law motion, Grande requested only the district court order a new trial on the issue of statutory damages. Nowhere in its briefing did it assert that only 662 copyrighted works in evidence were eligible. No fact finder has considered these issues. Therefore, we remand. And that's where we're at. The Fifth Circuit is remanding back to the district court to figure out whether it really is only 662 copyrighted works. I guess they will apply the same statutory damages number, because I don't think there's a ruling here that says to redo that number. So it's going to stay $33,333 per work times 662, which I can quick do on my old calculator here. Clear my calculator. There we go. 662. That's 66. 666. Yeah, that's good, Len. 662 and 33,333 and times. Nope, that's divided by. Times is the 22 million. That's where they get the 22 million from. Okay. So they affirm and provide a copy of the court's decision. Okay. So they affirm. Great. Whew. That is a very long ruling, but I skipped as much as possible, and I think we got through it. You understand where the issue is now? Is there really no due process right for a individual subscriber or user of an internet connection when that internet connection is going to be terminated because the connection has received accusations of copyright infringement from DMCA take notices? Yeah, through DMCA takedown notices. I don't think there's any way of capturing the due process right of, if you're going to take this action of disconnecting an infringing account without giving that account an opportunity to prove its innocence, then I think you've got a due process violation there. At the same time, I have seen so much piracy in my life and in my career that it's really hard for me to believe that the ISPs are receiving and the music companies are sending totally illegitimate takedown notices en masse. Millions and millions of completely illegitimate takedown notices. Definitely there are illegitimate takedown notices. There are. We can discuss and argue all day over how many are illegitimate. It's a high number of illegitimate takedown notices, but I don't think it's the majority. I don't even think it's 20%. That's just my opinion. We can talk about it. We can look up statistics and things. I'm not trying to take a hard position on this, but there's some level of proof, even though this isn't rock solid proof connecting the murder weapon to the murderer and the victim. I think in this civil type copyright case, I think there is enough. If someone did get disconnected, of course they would have the right to sue or appeal somehow. But I just think they should have that due process right on the front end first. Notice and an opportunity to respond before getting disconnected. But that's not this case, and that's not what the issue was in this case. So that's just me complaining. That's just me tilting at windmills. Let me know what you think in the comments below. Did we get these questions answered? What is the standard for culpability? Is a DMCA notice red flag knowledge? It is to the court. I don't agree 100%, but I'm leaning towards the idea that these people who got 1,000 DMCA takedown notices, or even 100, or even a dozen, there's enough there for the ISP to look into it at least. Then, did Grande present any evidence that their infringement was not willful? No. So they lost on that one just because they didn't appeal it. And what do we think the law should allow ISPs to do to accounts that are accused of copyright infringement? I personally think you should get a notice and an opportunity to respond. And if the infringement did not occur, there has to be some process in the law to capture that. What if the music companies are sending at least some illegitimate takedown notices? Shouldn't we catch that as well? Right now, there's no mechanism to catch that in the law whatsoever. It's one way. It's a very one-way, plaintiff-friendly law that does not provide much for defendants to do if they are the victim of illegitimate takedown notice or notices. Anyway, let me know what you think of that case in the comments below. All right, everyone. Thank you for sticking with me for so long. How many? There are still 54 of you here. Holy mackerel. So many comments. Let's see. Emmanuel Eminix. I'm doing okay. Annie Lunchbox. Pup time. Hello. How is the streaming going? Well, you see how it's going. Incarnadine, thank you for your 74th month of subscription. Katrina, IP address doesn't identify a user. It identifies a router, which may be shared by many users. Yeah, exactly. So you need more than just an IP address. The Rights Corp is Pants Act. Yeah. Rights Corp, Rights Haven. Yeah, sorry about that. I totally forgot the name of this rights holding company. Rights Corp is currently 15 cents, excuse me, 1.5 cents on Yahoo Finance. Okay. Revenue is $883,000 and net loss of $1.6 million. Yes, Mizara, this is again about the Fifth Circuit decision. It's almost like that's the purpose of the private equity system. Yeah, to like plunder companies. Let's see. Biscuits fraud lawsuit rattles the music industry. Limp Biscuits. Sorry, I didn't see the first right word. Limp Biscuits fraud lawsuit rattles music. These accusations are massive. Band alleges Universal Music Group owes it $200 million after concealing royalties. Okay, so there's been lots of talk about music industry math, so I can definitely understand. You'd sign a contract that says they can do X, Y, and Z, and then you don't get any money. And then you're like, wait a second, I see you making millions of dollars off of my songs. And they're like, no, we're actually losing money on your songs because we're paying everyone and having all these expenses and everything. And you didn't agree to any cost controls. So we're just going to spend all of the money and then call it a loss and not pay you anything. That is something that happens. Yes, Ewan can send out 14,000 crappy copyright claims, yes. So if you want to disconnect someone, just send a bunch of illegitimate copyright claims pretending to be from Sony to an ISP, and they have to disconnect someone. Don't do that. That was a hypothetical. That's mean. But like that's where the law allows for right now. It's still illegal. I'm not saying it's not illegal. It's not fraudulent, but the law allows the ISP to follow those takedown notices without any proof of anything more. Even if the two copies were the same, can they prove one of them came from the ISP subscribers? I'm going with yes on that one. The judge, the jury, remember we had an adversarial proceeding, a whole district court case in which Grande got to attack this, and they were not able to dispute that the copies came from the IP address. Whether that IP address can be connected to a particular subscriber, that's the big question. They didn't have to do that in this case because they're going after the ISP, not the subscriber. Would VPNs advertising pirate things with me, I don't log your information, be considered willful blindness? Yes. And there was recently, past year or two, a VPN that settled a copyright infringement case like this. And the settlement included that they would now log everything that they said they weren't logging before. So yes, if you use your VPN to infringe, some year these plaintiffs will eventually start pursuing the VPN software companies. It is critical, absolutely critical, critically important that the VPN providers never say you can use our service for copyright infringement. You're safe here. The fact that they have a peer-to-peer friendly option on NordVPN is getting close to that line. Peer-to-peer is okay. Does not automatically mean you're doing anything illegal. Lots of things. I remember my World of Tanks client used to be downloaded by BitTorrent. That was perfectly legal. There's nothing wrong with that. So you can still use VPN for peer-to-peer or whatever illegally, but you can also use it illegally. So they have to be really careful. Let's see. Just thinking. BT Open Zone. If you're a BT subscriber, which is included in your subscription cost, you can pay for a day's access. Okay, that's not BT as in BitTorrent. That's BT as something else. Sue copyright holders for making works that can be pirated. Anyway, yes, that's my show. I'm going to go have some food and play some Remnant 2 with my friends. I love you all. Have a good one, and I'll see you in the videos that drop. Oh, yeah. Before you go, I'm sorry that I have to be the bearer of sad news. If you haven't seen on my Discord, you may remember Ilsa and Nico from the Lawful Masses channel. They were my dogs. Well, Nico passed away on Thursday. He lost his second bout with doggy cancer. If you've seen the Adam Ruins Everything video on golden retrievers and cancer, it's a known thing that happens. Especially with maybe unethical breeders or breeders who don't put in the effort to keep their bloodlines safe from this kind of thing. Because golden retrievers are so popular, they are often inbred and they are often susceptible to cancers because of their lack of genetic diversity. So he only made it to 9 years old. And I'm very sorry to be the bearer of bad news, but he has passed away peacefully. He was with his new, very loving family. They posted a wonderful video of the past 2 years of his life. It's devastating to me. He was the best dog. I will love him for the rest of my life. And like Jon Stewart says, you got to get yourself that dog, man. Find yourself that dog that touches you like that. He was a great dog, and he'll be missed. And anyway, I didn't want you to go through a whole Fifth Circuit case with that on your mind, so I stopped saying it earlier. Anyway, have a good one. Have a good Sunday. Sorry to leave you on that, but also didn't want you to find out the wrong way. So have a good one. I love you all. Bye.